All right. Are you able to hear me all right, counsel?
Yes, Your Honor, I can hear you.
All right. Thank you. Just for the record, this is Pasco Municipal Court. Today is December 4th, 2020. It's now 9:23 in the morning. This hearing is being live streamed on YouTube, as well as the courtroom is open. Present in the courtroom with me is Mr. Mike Rio on behalf of the city of Pasco, accompanied by Mr. Bell, also here with the city of Pasco, and my clerk. Do you anticipate your client's going to join us today, Mr. Sabay?
No.
All right. All right. So are we ready to proceed on your motion?
Yes, Your
I guess I have one big concern. This is a substantive motion. And the defendant has a right to be here. I don't want to come back later and have Mr. Rollins say he should have been here or been able to participate and do all those things. This, like I said, this is a substantive process, and it's certainly an important procedure, and defendants don't usually get to not be here for a suppression motion to dismiss. So I have some issues with Mr. Rome not being available so that he can confer with his attorney and make arguments against what I might make, etc. And so I do have some concern about that.
And Mr. Spade, were you able to hear Mr. Rio's concerns?
Yes, Your Honor, and we're not going to make any issue out of that.
All right, and so Mr. Rom has elected to not attend today, correct?
Yes, Your Honor.
All right. All right, counsel, I have read your briefs submitted by both counsel, so we are ready to go. If you want to make any opening remarks or just get right into it, what do you prefer, Mr. Spade?
I respect your time, Judge, and I'd just rather get right into it. I'd like to hear what questions you have.
All right. I think that your briefs on both sides cover the issues very well. And Mr. Rio raises in his brief a response that some of the evidence contained in the affidavits could be construed by a jury that shows Mr. Rom knew he was involved in an accident. That is the watching a vehicle behind him brake hard and move his vehicle quickly, and then the vehicle flashing the lights at him, and then his conduct when he proceeded to the yard. What is your position with regard to those facts?
Sure, Your Honor. So Mr. Rom is driving a commercial tractor, pulling a commercial trailer, hauling a very, very heavy piece of heavy equipment, a Caterpillar track hoe, I believe it was. This is a vehicle that weighs in excess of 60,000 pounds. And if you look at what actually the contact alleged, it pretty much is to the mirror of the Honda Accord and potentially some part of the right front fender. And Mr. Rom has maintained since day one, you put a 4,000 pound car with just a minor side swipe compared to a 60,000 pound commercial vehicle, you're not going to feel it. It's just not going to happen. And that's what he told the officer at the scene. That's what he's maintained since day one. And if this case goes to trial, that's what our expert is going to show. It's just not possible. Where the city has elected to pin this is, first of all, they agree there is no direct evidence that he knew an accident occurred and that he intentionally fled. They know that. There's no evidence of that. Instead, we've got a string of facts that are kind of glued together in the suggestion that, well, if these things happen in this way, he must have known. Truthfully, Your Honor, Mr. Rom is a commercial driver. He sees, craziness on the roadway all the time. And this to him did not indicate an accident occurred. When he gets to the yard, and it's interesting, and I don't know if Your Honor has had a chance to view the body cam video from the officer. I have, and I've just taken some notes, and I'd like to share them with Your Honor very briefly. the first interaction between the police officer and Mr. Ram was at minute 2 of that video. And Mr. Ram is insistent. He says, I didn't hit her. Can you prove to me that the accident happened? And if you're saying I hit her, can you prove the opposite? Because I didn't touch her. I didn't hit her. Can you prove that she didn't hit me? And the officer just got very terse with him and just said, give me your driver's license or I'm taking you to jail. That's how that interaction began. If we fast forward to minute 7 in the video, the officer asked Mr. Ram for his driver's license and proof of insurance. Mr. Ram complied. He satisfied the requirements of the statute that he's being charged for violating. At minute 9:20, the officer gets in his car speaking to someone who's not an officer in his car. He had someone either doing a ride along or a girlfriend or somebody, but it was a female with him. And he says to that female, I'm going to charge him with hit and run because he went about his business and he's not cooperating with me. Where's the proof that he wasn't cooperating with him? There was one interaction in which actually he was cooperative with him. In fact, the officer says, and if he throws a big fit, I'll throw him in jail. Why? Because he was lippy with me. That's what the officer said in the car when he was speaking bravado to the female he had with him. Because Mr. Ram was lippy with me, I'm going to throw him in jail. I'm going to charge him for hit and run. Mind you, no substantive discussion yet whatsoever about what happened according to Mr. Ram. The officer didn't even bother to ask. Then at minute 37 in the interaction, the officer finally gets out of his car and makes his way to Mr. Ram to say, Mr. Ram, tell me what happened. And it's at that point Mr. Ram explains, I came around the curve, I had to make a left. As I was making that maneuver, I looked in my mirror, I didn't see anybody, it was fine and open. I make my I make my lane change. And at that point, I see a car slam on its brakes. I don't think much of it because it happens. Okay, maybe one of us was too close to the other, but I know we didn't make contact. He then makes a left at the next intersection, goes to the Caterpillar, and then sees once he gets to the Caterpillar plant that this car is flashing his lights at them. And he says, oh, I think it's one of my buddies. It must be. But he's not traveling a significant distance after that. He's in the Caterpillar plant in the yard and he parks his truck. That's when he gets out and this lady comes to him and says, you hit me. He says, I don't think I did. I didn't. Show me the proof. By that point, cops were already on the way. Authorities have already been called. And Mr. Ram's vehicle has, at that point, when you can truly consider that he knew about this, his vehicle was stopped. Authorities were on the way. He was always willing to provide insurance, never requested. And notably, the other driver didn't provide her insurance either, presumably because Mr. Ram didn't ask for it, but she's not being charged with anything. And then when police come, Mr. Ram explains his story. But it's interesting that the city makes a big deal out of what Mr. Ram told police when Mr. Ram told the officer that 37 minutes into the encounter, after the officer has already decided to charge him with hit and run because, quote, he was being lippy and uncooperative. And thank the Lord that we have body cam footage. There was nothing wrong with Mr. Ram's conduct at the scene. He was cooperative. He was insistent. I didn't hit her. This is a serious charge for a commercial driver, someone claiming that you hit and ran. That's a very serious charge. And he maintains he never hit her. So we go to where the city's problems are. They have to prove an accident actually occurred. Now, it seems that there was contact between the two vehicles based on what we have after the fact. But Mr. Ram didn't believe that at the scene. And so in order to trigger even the reporting statute, there has to be an actual accident, not one alleged. Now, and this timeline is important because all of this comes to fruition. All of the duties to report, all of the duty to share information came to fruition at the Caterpillar yard. Before that, there was no duty on anything because he didn't know he was involved in an accident. He didn't observe any evidence that there was an accident involved. But when he finally did, he cooperated and complied. So Respectfully, Your Honor, I understand. I mean, they got to say something, right? Their cop charged this guy because he thought he was being.
I would object. He's casting aspersions that somehow I have to fabricate something to support my officer. If Mr. Sabay wants to make that kind of categorization, he should do it in writing to this court. But to make an argument that I can't respond to in writing back to say I'm just fabricating something is wholly out of line.
I think your objection is noted. I'll take into consideration. I think I'm able to disallow or ignore any evidence that I don't, or statements that I think are inappropriate.
And for the record, Your Honor, I'm not casting aspersions. I'm not saying Mr. Rio is fabricating anything by any means, but he does have an obligation to represent his client and defend the charge. And the defense of the charge is that there was circumstantial evidence based on two things that occurred 50 minutes before any constructive note or any actual or constructive notice actually occurred. And when you actually look at what happened, you realize that the only reason this charge exists is because the officer at minute 9, when he gets into the car, says, I don't think he's cooperating basically enough, is what he says. I think he was lippy with me and he's not cooperating enough. I'm going to charge him with hit and run. And quote, if he throws a fit, I'll just throw him in jail. To which the female occupant of the vehicle says, well, that'll fix the problem. And he says, yes, it sure will. Those are the circumstances we're dealing with. And those are not fair circumstances to charge a commercial driver with hit and run, where there's no proof he knew about the accident until he was at the yard, where when he got to the yard, he was fully there, ready and able to cooperate. Cops were already on the way. And actually the video, again, thank goodness it exists, shows that he was cooperative. He was perhaps upset during the beginning of the conversation, but nothing inappropriate. And I urge Your Honor, if you're going to rely on that statement, to go look at the video at minute 2. From minute 2 to minute 3 is the first interaction. It's a 1-minute conversation, and you'll see what the officer perceived as being lippy and inappropriate that then turned into a hit and run charge.
All right. Thank you, Mr. Sabay. Mr. Rio, the city's response.
Your Honor, this situation is simply this. First of all, we have disputed facts, and I have alleged that. The NAPSTEC case says where there are disputed facts, the court has to mandatorily deny their essentially summary judgment motion. How do we know that we have disputed facts? Well, even in the reply brief, they say, assuming arguendo, the defendant did finally learn that the accident occurred at the Caterpillar yard. You can't say, for the sake of argument, my client learned. The NAPSTEC case says they have to agree that that's the facts, that those are the facts. And if they dispute those facts, then the court has to deny this. So their argument that her telling him he was in an accident, what didn't happen or wasn't enough, that's something for you to say, hey, this is a disputed fact. But here's the situation. You have a commercial driver who says he makes a turn, he sees a car take evasive action. Then that car tries to get his attention for several blocks, couple blocks, or however far it is from that location to the Caterpillar yard. Once he gets to the Caterpillar yard, that driver tells him he was in a collision. And he essentially tells that driver, based on what she says, you have to prove it to me. Well, the city has to make a prima facie showing, not proof beyond a reasonable doubt, there isn't really a standard other than prima facie here. That's what the city has to prove. To a jury, you have to prove something completely different. But here, this is a summary judgment motion, essentially. And what I have is a victim who says, I was hit. There's damage to my car. I followed the semi. I got his attention at the yard, and I told him it was a collision, and he told me I had to prove it to him. Now imagine that's the rule. You're in a collision. You can say, I didn't know. I didn't know that my vehicle hit yours. It was just a scrape. I wouldn't feel it. I wouldn't know about it. So you have to prove it to me before this RCW comes into effect. No, the statute says involved in an accident, not proved to the driver's satisfaction, proof beyond a reasonable doubt, by a preponderance, whatever. It says when the driver becomes aware that they're involved in an accident, they have an obligation to share information. With whom? The other driver. not law enforcement. The idea that Mr. Sabay says, well, law enforcement was already on its way. That's not the standard. The standard is when the person knew they were in an accident, they have to provide that information. That didn't happen here. Mr. Rom went about his business. He went around the yard taking stuff off, doing that. In fact, in the video, you see the officer tell him, hey, you need to come down here. And Mr. Rom essentially is like, why? You got to prove to me that I was in an accident. I don't have to come down and talk to you. Well, that's when the officer first says, hey, do that or we're going to have some issue here. That's what the city has here. And that is something that a jury could look at and say, Mr. Rom knew and he didn't want to cooperate. They're trying to substitute law enforcement for the other driver. The victim in this case says, hey, he wouldn't even talk to me. He walked away from me. She didn't have the ability to say, and the statute doesn't say that the other person has to demand those things. It's the obligation of the other driver, once they know they're involved in that collision, to provide those things. It's not, the other driver didn't ask me for them, so I can say I don't have to provide them. It's very clear he didn't provide that information. So, until very later, okay? And in fact, I put in my brief how many minutes it was from the time the first phone call came in at 5:03 until officers arrived at 5:18. So there's a 15-minute period before the officer ever gets there, where at some point she gets to the yard and tells him he's involved in this collision and he had an obligation to provide that information when he didn't. And so we'll ask you to deny the motion.
All right. Anything else, Mr. Sabay, you'd want me to consider?
Absolutely, Your Honor. I'm not talking about disputed facts. That's the red herring here to get the court to just simply deny this motion. We don't dispute, it's agreed, that after Mr. Rom made his lane change, the vehicle involved, the other vehicle, Mr. Rom saw it braking. That's undisputed. That, however, is not evidence of an accident. It is undisputed that as Mr. Rom was pulling into his final destination, he was pulling into the Walmart parking lot, he was pulling into the Caterpillar parking lot, that he saw that vehicle flashing its lights behind him. That's not disputed. That is not evidence that an accident occurred. It's simply not. Once the vehicle stopped, true, Mr. Rio is true. The occupant of the other vehicle came and said, you hit me? Mr. Rom questioned it. 100% true. That's not disputed. But by that point, Your Honor, it's notable. Both vehicles were stopped. There was no running involved after he learned an accident occurred. If you use that as the operative time, there was no running involved. Vehicles were stopped. The trailer was stopped. The other vehicle was stopped. At that point, officers were already called and were en route. And it goes by a double standard. She never asked for his insurance. He was happy to provide it. And when the cops came, he was happy to provide his insurance information. But she never asked for his, he never asked for hers, knowing, I don't think an accident happened, but whatever, cops are on their way. And Your Honor, if you're so inclined and the court allows me to share, I do have the video open. If at all you're considering the initial interaction with the police, Mr. Rio, we can all describe things differently. I disagree with the way he described it. When the cop walks up to Mr. Rom, he says to him, hey, turn off the tractor and come down. And he says, why? It's fine to ask an officer that you want to maintain your distance. And he says, why? He says, because if you don't, I'm going to put you in jail. Mr. Rom complies, steps off the tractor, walks down. And then the officer starts saying some things that don't really add up. And Mr. Rom's like, well, wait a second. Are you saying, how can you say that I hit her without considering whether she hit me? If there was contact, fine. But if you're blaming somebody, you need to consider who hit who. How do you know this versus that? And that's when the officer said, look, I'm not going to get into that. All I know is that there was contact between the vehicles and you're saying it didn't happen. So I'm going to need your license and registration. Mr. Rom said, here you go. last I checked, asking law enforcement for the basis of their opinion does not amount to hit and run. So when you sift it all through, there are no disputed facts. The two facts that they use to hinge on the hit and run is the braking and the flashing lights. Neither of those prove an accident occurred and knowledge of the accident and intent to hit and run. When he finally knew what happened, he stopped. He was willing, ready, and able. Cops were on their way. They maintained their distance from one another because obviously there was a dispute going on, and that doesn't amount to a violation of the statute.
All right. Thank you, gentlemen.
I just want to say one last thing, Judge. It is correct. And the officer couldn't have gotten there for 2 hours. This victim has to sit there and wait. The statute doesn't come into play until the officer arrives. And the statute's very clear that law enforcement's not mentioned one time in the statute.
Well, that's not true, but.
In the subsection 2A, law enforcement is not mentioned at all, and that's what we're talking about, where the duty comes from.
And I am, for the record, reviewing 4652020 subsection 2A, as well as subsection 3, which describes the information that must be provided. And I don't think the statute requires that the person be the at-fault driver in order to participate in the exchange of information. So whether or not Mr. Rom believed he was at fault is not relevant, I think, to the issue about whether or not RCW 4652020 could come into play. What I see here is perhaps not so much a dispute of facts, but a dispute of the way the facts may be interpreted. And we all know that circumstantial evidence is as good as direct evidence can be considered by a trier of fact. I believe the city has stated a prima facie case. Whether or not they can prove this beyond a reasonable doubt is a different standard, and that's a standard for the trier of fact. So I think the city has met its burden in this case. There are a couple of issues that I see could go to the jury. Whether or not at the time of the contact, Mr. Rom knew he was involved in an accident based on his observations as an experienced driver, and then his response at the yard telling her, no, I didn't, prove it, you need to leave, you're trespassing. You know, those things, if you combine them, are these actions of somebody who might believe that he was involved in an accident but doesn't want to be responsible. I think those are issues that a trier of fact needs to resolve. And when, in fact, does the duty arise here? I think, did it arise when the other driver told him, hey, look, we were involved in an accident, and he refused to comply, went forward, did his job of unloading the tractor or whatever else he was doing, and wouldn't communicate with her? Did he have a duty at that point to exchange information? Because Mr. Rio is correct. 4652020 subsection 2A says the driver shall remain at the suitable location until he or she has fulfilled the requirements of subsection 3 of this section. Moving the vehicle in no way affects fault of an accident. So I think there are several issues that can be resolved or should be resolved by a jury in this case. So I'm going to deny your motion, Mr. Sabay.
May I just ask for one clarification? I'm not re-arguing, I promise.
Yes.
Is the court making a ruling on the legal question involved, which is whether a duty arised, as the city has alleged, when a vehicle brakes and when a vehicle flashes its lights? Did a duty arise at that point for Mr. Rom to pull over his truck and see what that vehicle wants, presuming potentially an accident happened and fearing hit and run? Is there?
I am not making a legal ruling that the duty arose at that time.
Okay, well, would the court be open then to briefing on that issue? Because I think that's really at the heart of this is, and my argument did he have a duty to do so when those two things occurred? Because by the time he reached the lot, he has satisfied that duty. So should we schedule a follow-up hearing on that issue when the legal duty arose? Or
I
is
don't think that that's going to change my mind in this case, because the statute says the driver of any vehicle involved in an accident resulting only in damage to a vehicle which is driven or attended by any person or damage to other property must move the vehicle as soon as possible off the roadway or freeway, main lanes, shoulders, medians, and adjacent areas to a location on an exit ramp, shoulder, the frontage road, or the nearest suitable cross street or other suitable location. So I guess the dilemma here is, at what point does a person believe that Mr. Rom either knew or should have known that he was potentially involved in an accident? Because as you describe it in your facts, he continued to the yard and then she followed him in. Is that moving the vehicle safely to an area where they could discuss I don't know. Okay.
Good.
All right.
Thank you for that clarification, Your Honor.
All right, gentlemen, Mr. Rio, you want to prepare any findings
Certainly, Your Honor.
and do you want to set it for a hearing to enter those, or do you want to forward those to Mr. Zabay? If he agrees or you come to an agreement about what the facts are, we can enter them and then set this matter.
That would be great, Your Honor.
Mr. Sabay, well, as far as getting things back and forth, so I don't think that unless he does.
All right, and then finally, gentlemen, I'll indicate this. Yesterday, I signed an emergency order for Franklin County that there will be no jury trials in December, and including January 6th, all of those will be reset to a later date, given the uptick, and Franklin County being one of the highest, the county with the highest transmission of the COVID-19. There won't be any jury trials all the way through January 6th, which is the first Wednesday in January. So we could set another remote hearing for entry of the findings and then discuss a trial date at that time. Does council believe that's appropriate?
I'd be fine with that if Mr. Sabay is.
All right. And Mr. Sabay, you're more than welcome to appear remotely at the hearing as well.
Thank you, Your Honor. And I agree with that proposal.
All right. So let's take a look at the calendar. Why don't we, if we have availability, why don't we just set this on another Friday?
January 8th.
That works for me.
All right. Let's reset this hearing to January 8th for entry of the findings as a result of this hearing, and discussion about when a trial will be set at that time.
Thank you, Your Honor.
Thank you, Your Honor. Appreciate it.
All right. Thank you, Mr. Sabay, for your cooperation, your appearance here today. You're excused. Have a good day.
Thank you, Your Honor. Appreciate it.